Hi, I'm Martin Perdikin, the Dean of Concord Law School at Purdue University Global, the nation's first fully online law school since 1998. Welcome to this latest installment in our Distinguished Speaker webinar series on the topic of the battle to recover stolen Holocaust-era artwork. Now, to discuss this topic, we are fortunate to have with us today two distinguished guests, Mary Christine, or MC Sungaila, and Lawrence Kaye, who have litigated a major case involving an effort to recover a famed Picasso painting all the way up through the Supreme Court of the United States. MC Sungaila is an appellate partner with Haynes Boone LP. She's briefed and argued numerous cases before the highest courts in the state and nation, and I understand has actually just found out she won another appeal in the Ninth Circuit just this morning. Among her other many accolades, in 2017, she was awarded the Ellis Island Medal of Honor, whose recipients have included US presidents and Nobel Prize winners, among others, for her professional achievements and humanitarian and pro bono work. Lawrence Kaye is a partner with the firm of Herrick Feinstein LLP, where he's a co-chair of the firm's art law group. He's recognized, among other things, as a leader in the art restitution field, having successfully filed claims on behalf of foreign governments, museums, the heirs of Holocaust victims, and others. And he writes and lectures extensively in the field. MC and Larry, thank you so much for joining us today. I hope you and your loved ones are staying healthy and safe in these crazy times. Before we get started, I also wanted to acknowledge that today, June 19th, or Juneteenth, is celebrated in this country as the day that slavery ended in the United States, and its recognition is particularly important this year. Many law firms and other organizations have recognized it this year by giving their employees the day off, so I appreciate you joining us today to have this conversation about your efforts to address historical injustices in an obviously very different context. I also want to remind those watching via Facebook Live that you should feel free to post questions of your own, and time permitting, we'll try to address some of them either during the conversation or towards the end. So let's dive into the topic itself. And let me start by asking both of you, I guess we'll start with Larry first. How long have you both been involved in Holocaust art cases, and how did you come to even begin working on them?
Well, I don't want to, first of all, Marty, thank you, and thank MC for putting this panel together. You've done a great job.
Thank you both.
And I don't want to date myself, but I started working on these matters in the 1960s. While I was in law school, someone handed me an assignment. I spent the next month trying to figure it out. And it took life from that point on. The case I was working on was not quite a Holocaust restitution case. It was a case where a German museum had very important dewars stolen by an American serviceman during the war. And that case went on for 13 years because it turned out that the court thought that our client, the Weimar Art Museum, was really an armor instrumentality of the German Democratic Republic and hence not recognized, and hence couldn't use our courts. But we kept the case going so long they got recognized. So I cut my teeth on that case for 13 years. Then I got involved in cultural property recovery cases for foreign sovereigns. And it became a natural segue in the 1990s, after the 50th anniversary of the end of hostilities, when people started to rediscover the Holocaust. There had been hardly any restitution cases involving the Holocaust between the end of the war and the mid-1990s, except for the Bernstein case, which was early on but very important. So when the mid-90s came and people were writing and thinking about this, restitution cases started to occur. There was a conference in Washington, which we'll talk about, I'm sure, today, the Washington Conference, where 44 countries convened to talk about restitution and adopt principles of soft law to encourage restitution. And we had two of the earliest cases, one involving a Sheila case called Portrait of Wally, and another involving the heirs of Jacques Hoodsticker in Holland. And I'll talk about those a little more later.
Great, thank you. MC, how about you? I know that your background tends to be more in appellate practice generally. How did you get involved in these types of cases?
So I've been involved for close to 20 years now, and my very first entry into them was assisting Randy Schoenberg in preparing for oral argument before the US Supreme Court in the Maria Altman versus Austria case, which has been made into a movie, Woman in Gold, in the last few years, and is one of the more famous successful recoveries of 6 very valuable Klimt paintings from Austria. So that's how I started, was helping Larry prepare for his very first Supreme Court argument and his second appellate argument ever in that case, which was successful. And then after that, Randy was, like Larry, was involved in a number of these cases and would contact me to write amicus briefs and support his positions and strategize in them. So I worked on some of those, and then it's the same kind of thing as Larry. It just sort of snowballs. The more of those that you do, people say, oh, you know how to do this. We really liked your brief in that case. Would you write one in our case? So it's just kind of carried on since then. When there's a Holocaust art case, I'm usually involved in some way or another. So, and that's how Larry and I got to know each other, was from some of his prior cases to this one as well.
Well, that's great. Now, especially because this is Juneteenth, I know I do want to focus on the Holocaust cases, but I thought maybe if you could talk for just a few minutes about how these Holocaust art recovery cases fit into the broader context of historical reparation or restitution movements. MC, do you want to start off talking a little bit about that?
Sure. So that is a very fair point, that this is part of a larger cultural return and reparation set of questions, which has arisen now in our discussions currently about the propriety of potentially reparations with regard to slavery in the United States. But also there are many other circumstances where this has been a question. We have in our own country the Japanese internment and reparations with regard to that. There are also the Armenian genocide and return associated with that. Even more recently, there's Rwanda, there's Cambodia, and there's also ISIS, quite frankly, which is also just kind of getting started. So the question in these cases has to do with the state. The state is involved in the injustice in some way, at some point along the way, the deprivation of the property. And how do you respond to that? Do you respond? Reparations are kind of a rough justice. You're not going to get the full value of your particular property or situation, but we're going to try to approximate that, some kind of recovery for everyone at some point in time. And that has been the approach even with Holocaust with regard to property, not art. There has been some payments and sort of rough justice with some of the countries in Europe, but art has been carved out of that, in part because it's a very unique object. And there wasn't anything set up by the Allies or the United States afterwards for a clear venue to clear those claims. It was really left to the individual countries, and the individual countries did not set up a particular way of dealing with these art claims. So it's in that larger context, because whatever happens here with these Holocaust art cases, contributes to a broader body of work and approaches to a number of different situations that unfortunately recur.
Yeah.
So it does have that impact. And then also with regard to just the continuing impact in the Holocaust art context, so much art passed hands during that war. There's various estimates, between a quarter and a third of Europe's art holdings changed hands, properly or improperly, during the war. And
Wow.
There's at least one estimate that says there's 100,000 works still outstanding worth billions of dollars that people haven't been able to track and would like to find and potentially would like returned. So it's a problem that persists.
Wow, I gotta say, I had no idea that the scope of this issue was that broad. Larry, I don't know if there's anything you wanted to add on that topic on this point.
that number 100,000 is starting to rise. People still think there's more out there even. And I think the thread that runs through all of these kinds of cases, not just the Holocaust art cases, is an effort to find solutions to previous extraordinary wrongs. And we look for perfect justice, and it's very hard to find. So we try to get a modicum of justice. There are a lot of different stakeholders that are affected. I mean, some of these, as MC said, went into commerce. And, 50 years later, someone paid a lot of money for something that had been commerce for 50 years because the governments that were in charge of restitution after the war, didn't do their job. They have some thoughts, they have some arguments too. So the way we tried to address it, or the way people tried to address it in respect to the Holocaust, was that conference that I referred to that took place in Washington in 1998 when 44 countries came together, and they carved out 11 or 12 principles to apply to art. It was soft law, saying we have to recognize that this happened. We have to encourage Holocaust claimants to come forward with claims. We have to encourage possessors to deal with those claims in an appropriate way. And they came up with the notion of fair and just results. And that's not very concrete, but that's what the courts and the stakeholders have been trying to figure out ever since. They were helped a bit 10 years later when there was another conference in Terezin, where they came out with the Terezin Declaration. I was there, and the Terezin Declaration, still soft law, put more teeth into it. And the two most important things, I think, were that it noted that there were all kinds of takings during the war that should be remedied, including forced sales, confiscations, sales that were under duress, which will become very relevant when we talk about Lefman. And also that every country should go back and try to fix their law up so that impediments, procedural impediments, like the statute of limitations and other technical impediments, would not bar the Holocaust, the proper Holocaust plaintiff, from getting a decision on the merits. So we've made some progress. It's still not perfect, and we'll talk about that when we talk about the cases.
Yeah, well, speaking of that, let's turn to the case that you and MC both worked on most recently on behalf of the Zuckerman family, taking it all the way to the Supreme Court. Now, Larry, since you handled the case from the very beginning, why don't you tell us how that case got started and sort of, how it then moved up towards the Supreme Court level when MC got involved?
This could take a couple of days to tell you that, because it really got started in the mid-1930s in Germany, when Paul and Alice Lefman, who were affluent, successful people, had a company, had houses, had to flee Germany because of the Nazis, had to pay significant flight tax, was able to acquire a property in Italy that was owned by Germans, but then when they got to Italy, switched it, exchanged it at a significant loss. Hoped Italy, which was one of the few countries that allowed in German Jewish refugees, would be their haven. But then fascism took hold. It had been starting anyway, but it got much more institutional. And then the Nazis followed them to Italy. The Nazi police cooperated with the Mussolini regime. They started making lists of Jews, and the tensions became quite terrible. And then in 1938, there were rumors that there were going to be fascist laws implemented in September. The Lefmans couldn't work. They feared for their lives. The horror was starting to happen. They lived in Florence, and a block away, Hitler came with Mussolini, and there were videos, there's footage of it, amazingly. And if we'd ever gotten to trial, we would have shown it. So they were desperate to leave. And luckily for them, the one most valuable asset they had, which was the actor by Picasso, which they bought in 1912, they had sent to Switzerland for safekeeping. And it was their only real asset. They knew they would have to leave. They didn't know where they would end up, what would happen, how long this would go on. So they had tried to sell it, but couldn't get a good price for it. But finally sold it to two Jewish dealers who clearly exploited their plight for a very low price, lower than they'd wanted before, and a fraction of its market value. And they sold that and then left and went to Switzerland temporarily. They couldn't get in permanently, and then to Brazil to sit out the war. And then after the war, returned to Switzerland, but not in the same condition they were before. Then years later, many years later, in the early 2000s, the great grandniece of the Lefmans, Laurel Zuckerman, with all the attention we're giving to the Holocaust, started searching and looking at her family's history, found a reference to the actor at the Met, which indicated that Paul Lefman had bought it, but the provenance was corrupt in that though it was changed over 50 years, never indicated that the Lefmans had it during the war, during the Holocaust. But anyway, she made inquiries of the Met for years, and they never gave her full answers. And finally, she retained us. We negotiated under the Washington principles, which said try to resolve it, but nothing ever happened. And we started suit. And we sued in the Southern District of New York and alleged duress. There were choice of law issues, whether Italian law applied or New York law. We said we went under both, but we thought Italian law was more appropriate. The court, on the pleadings, dismissed the case on the grounds that we had not sufficiently pled duress, even though 5 pages of our complaint talked about the atrocities and horrors that had occurred in Germany, were occurring in Italy, and why the Lefmans, in light of this terror, had to leave and sell the picture at a loss. The court astoundingly said that we hadn't sufficiently pleaded duress. They also relied on New York cases that said you need the counterparty to be the person who extends the duress, can't be the fascist government. First of all, we had cases that said that's not necessarily true. It's just that most of those cases arrived in a normal commercial context. They'd never dealt with a Holocaust issue. But nevertheless, she dismissed, and that was the only issue she dealt with. So we took it to the Court of Appeals, the Second Circuit Federal Court of Appeals. We had a wonderful argument. They let us go on for an hour. 99% of it was based on the duress issue, and they were very, very favorable. There was 1 minute of discussion on the statute of limitations and the HERE Act that was raised by one of the judges. It really hadn't been briefed. And then we were astounded to get a unanimous decision dismissing on the ground of laches, where the court gave short shrift to a Supreme Court case, Golvatello, which clearly said when there was a federal statute of limitations imposed, laches wasn't applicable. That happened in our case because of the HERE Act, which MC is going to talk about more when she talks about the Supreme Court. But astoundingly, they gave the Supreme Court cases short shrift and said, even though that the federal government, the Congress had unanimously adopted a statute that imposed a uniform statute of limitations that was intended to comport with the Washington Principles and Terrorism Declaration and make it easier for Holocaust victims to sue on a unified national basis rather than in each state, they found laches. And they said that the HERE Act, even though the whole purpose was to make it easier to sue and not have procedural technical impediments, didn't include laches because the words weren't in there, even though the Supreme Court had already ruled that you don't have to have it in there, because if there's a federal statute imposed, laches can't be argued either because it would defeat the whole purpose of it.
Well, it seems like a stunning turn.
It was a stunning and shocking turn. And that's why we decided to petition for certiorari to the Supreme Court after rehearing was denied in the Second Circuit. And
so MC, let me, if I can, turn to you now, since I believe that's the point at which you got involved. And before you talk about what happened in the Supreme Court level, maybe just give us a quick primer, because even for those of us who's been through law school, we may not remember much about latches other than a dim, painful memory from civil procedure. What is latches, and how does it differ from the statute of limitations?
So, it's an equitable doctrine that says basically if you've kind of sat back and waited too long to bring your particular claim, that can be invoked by a defendant, even if the statute of limitations is otherwise met by the plaintiff. That you can say, gee, based on these equitable principles, we're not going to allow you to bring your claim. So here the issue that the primary issue that we raised to the U.S. Supreme Court had to do with that question, whether a non-statutory defense, an equitable defense like laches, can be used to bar that a claim that would otherwise be timely under the HERE Act, which set a very clear, uniform, as Larry mentioned, uniform nationwide 6-year limitations period to bring these claims. Now, this is a very, there was a lot of unanimity in Congress and in the legislature to pass this. It's a new statute, relatively, from 2016. And so this was the first case involving a ruling at that level on the application of the HERE Act. So that made it a little bit of a challenge for a cert petition because, as we know, the clearest case for crying out for immediate review would be a case where there are conflicts and there are different decisions about the application of the act by different circuits. But the Second Circuit got to it first. And while there have been some indications from even a district court in New York and the Ninth Circuit in another case that perhaps this is not how they would have looked at the HERE Act, but there wasn't a direct conflict. So in the cert petition, we relied on this involves a national statute that we need to understand its application. It is clearly a nationwide importance question.
Right.
It is a question also that take this case rather than a later case waiting for a conflict precisely because of this 6-year period.
Right, you wait until another case.
People need to understand how this applies.
Already, right?
Yeah, exactly. And people might sit on their claims thinking, well, I might not, e.g., the Second Circuit said I might not have one. And it's not cheap to bring these claims and it takes a lot of effort. So maybe people would be disincentivized to bring them. So we raised all of those arguments in the petition. And we had many amicus supporting us. In fact, the members of Congress who voted for this statute said, well, this is not what we meant. We support the application in this case. And a number of other, like I said, 6 amicus briefs, which is a significant amount. I think that the statistics show that the difference between like no amicus brief and 2 or 3 amicus briefs greatly increases the chances of review up from a very low percentage, like 3%, 4%, to almost 25%. So we really made the very best case that we could with all of the amici that we could. And
I have to assume it's probably relatively rare to get amicus briefs from actual members of Congress, right?
Yeah, that was a bit of a challenge, but they were, appeared to be equally shocked to Larry and saying, wait a minute, this is, we meant to have this nationwide application. And at the very least, if you think we didn't do it right, please let us know so we can fix it or we can do something else. So that was the question there. And I just wanted to mention also, we have a website for the case that's still up called ZuckermanCaseFiles.com. And all of the briefs are there from the Supreme Court, all of the amicus briefs and the petition, and the Court of Appeals, the District Court, and also all of the press that accompanied the case. So if people are interested in following up, they can go there and see it.
Great. Yeah, I mean, actually, that's the site that I look to understand some background of the case, and it's very helpful to, they're all very well-written briefs, well-written, if not well-reasoned opinions. And so it's sort of easy to get the context of the factual background and the legal issues by reviewing that. So what has happened since you filed the cert petition in the Supreme Court?
So we filed our cert petition, and the Met said, no thanks, we're gonna sit this out. We're not gonna respond unless you ask us to. And then it went to conference. I think part of that strategy was to get it to conference faster and possibly interfere with our efforts to get amicus briefs filed in time. I think that was part of that strategy, but it didn't work. We got our briefs filed, and but the Supreme Court denied cert. And I do think there's a couple of factors to that. One is the factor I mentioned in the beginning. They tend to like to wait until there's a conflict, despite the point we made with regard to how this statute operates. The second aspect is that the court has been very hesitant to take on Holocaust-era cases. It took the Altman case. There have been many more since then that it has denied review in. And when it does consider it, when it asks for the views of the Solicitor General, the United States, with regard to a particular case, the United States has not generally been in favor of recovery or of the court reviewing a case. So in our case, we didn't have that kind of issue where you would call for the Solicitor General, because this is a really truly domestic case. It's New York state law against the Met, which is here, and New York state law claims, and a federal statute with regard to timeliness. So foreign policy interests and things like that did not come into play as they would have in Altman, where the case is against Austria, and you want to know what's our policy with regard to these objects, because our courts are going to start to interfere with another country's right to hold property, and we want to make sure we hear all of those views.
Right.
But that's definitely a combination, a trend that's troubling, because these cases while they do have implications, of course, here, but they also can lend guidance to how we might handle other types of claims stemming from other genocides. So it's an important thing to look at. I think that the court also sometimes can look at the cases as being more specific to the particular facts of that case. I don't think that's necessarily true, but it's definitely an issue with these cases, that it might kind of tug at your heartstrings, but the court might say, well, I don't want to step into that. And I think that it really just involves these particular claimants.
And so let's talk a little about putting the Zuckerman case into the context of other Holocaust art recovery cases. You mentioned issues about the government taking position, especially if it's involved, another nationality is involved, another government. What are some of the kinds of issues that tend to recur, and what are some of the more common barriers to recovery? Is the Zuckerman case unique, or have we seen some of these patterns before? You mentioned the Altman case. I know there are others. What's been your experience in that regard, MC? And then I'll ask you the same question, Larry.
Yeah, so I think two things. The primary issue is that very few of these cases actually got litigated on the merits of the claim. It's really procedural hurdles, which gets to why Congress was wanting to enact the HERE Act. There are a lot of procedural obstacles to having the cases heard. It can be, as in Zuckerman, the statute of limitations. But there are a lot of other issues too that kind of fall in the same gamut. In Altman, it was the Foreign Sovereign Immunity Act. Is Austria immune from these particular claims? Can you even sue Austria? And how do you interpret our sovereign immunity statute in that context? Also at the motion to dismiss stage, that it made it to the US Supreme Court. That is one of the rare cases, as I mentioned, where there was recovery. And that was not because the case was continued to be litigated after the Supreme Court in the US courts. Maria Altman made a calculated decision that she wanted to see an answer sooner rather than later. She was advanced in years and she wanted to know whether she was going to get these. And the more streamlined approach was to go through an arbitration in Austria. And that's what she did. If she had stayed in the US court system, it's very likely there would have been more procedural roadblocks, as many roadblocks as you could put up to stop it from getting to an ultimate resolution. So they went to arbitration in Austria and got that. Amazingly, the Austrian arbitrator gave it to Maria Altman, which you would not think would happen in a home court advantage, but it did. So that is one example, but even in that case, the case started in 1999 and the artwork was recovered in 2006. That's fast in these cases, which is not fast at all. As Larry mentioned, he started with the Zuckerman case quite a few years ago. And also right now, there is a case that will be argued next month, once again, in the Ninth Circuit, the Kaye case, which involves a Pissarro painting. That case has been going for 15 years. Wow. I was involved in it when it was first before the Ninth Circuit. And it finally made its way back down to a trial. It had a bench trial. And so now the appeal involves an appeal of the bench trial. And that involved really every kind of procedural question you could have, from the statute of limitations to choice of law questions, as Larry mentioned. Does Spanish law apply or some other law apply? And if it does, what does it say about this and how do we interpret it? That's another issue that comes up in these cases a lot too, is the choice of law question. But I would say the commonality between these cases is the length of time it takes to even get through these procedural questions, and then the number of procedural hurdles that arise.
Now, Larry, what's your perspective been as well? Have you seen similar themes or patterns or other recurring issues or barriers to recovery?
Sure. As I said, we had very early cases in the 90s, one of which was Portrait of Wally, which was owned by a Jewish Austrian dealer, and they Aryanized her gallery during the war. But this was a personal picture in her house, but a Nazi agent came and said he wanted it anyway. They had to give it to him or they wouldn't have left. She went to London after the war. She tried to get it back. A collector named Leopold, she asked for help. He said, "Oh, you can't get it." And then he went and got it. And then there was this confusion after the war as to where it was supposed to be. But he got it back and he kept it, but he made, in retrospect, a mistake of lending it to MoMA, Museum of Modern Art in New York, where the family got wind of it. The district attorney in New York City seized it. The Court of Appeals, after quite a bit of litigation in New York, said museums are immune from lawsuit automatically under New York law, but they weren't under federal law because you had to make an application to get the immunity, which no one did. I assume someone got fired for that. But the fact is the feds moved in and they seized it, and we litigated it with the help of the US government. They were on our side on that one. So it eventually, again, took 10 years. And at the end of 10 years, I think the only reason it didn't go to trial is because Dr. Leopold died right before the trial. It was settled, and the family, it stayed in Austria, but the family was compensated the market value at the time, which was about 10 times what it was worth, I think, at the beginning of the case. So we were very optimistic after that. But then in the private sector, it didn't go as well, because one of the problems with Holocaust property in the US, either it's not worth very much, which creates one problem, because it's very expensive to litigate these cases, and it's very hard to figure out how to get low value but very important emotional property back. And the other side of it is the very valuable works. I think, as somebody said, the Lefman picture was worth over $100 million at the time of the lawsuit. And in those cases, the holders, were generally American museums, want to hold them. They don't want to give them up. And then somehow the American museums feel remote from the Holocaust. There's been much better success in restitution in Germany and other European countries. And in the US, no. So there was this important dealer in Holland, the most important Jewish dealer in Holland, Jacques Houtstikker, and he fled. He had a gallery, but he fled with his wife and young son. He died on the passage over in an accident. After the war, his widow went back and tried to get the property back in Holland. I think MC may have mentioned there was a policy of restitution after the war, external restitution, where the Allies felt it was too much of a job to get all this back to the right people. So they left it to the states, to the individual countries. And Holland, like others, adopted rules that really weren't intended to get it back to the pre-war owners. And I remember at the beginning of the Washington Conference, Lerman, who was the chair, said one of the problems of the post-war is that all these countries which adopted restitution regimes, Bennett took advantage of the cataclysm in order to get the property that should have gone back to the Jews. Holland was no different, and the government said it owned it. These particular pictures, which were Adam and Eve by Chronic the Elder, were part of a collection, but they were sold by the Dutch government in the 1960s and ended up at the Norton Simon Museum. And they had it for years. It was discovered there finally in the early 2000s. We made a demand. There was 2 unsuccessful mediations because they said they would be honorable, but they weren't. So then we sued, and the district court dismissed the case. We sued under a very enlightened California statute that made a special statute of limitations for Holocaust cases. But the court declared it unconstitutional, that it impeded on our foreign policy power, the Fed's foreign policy power.
Wow.
That was affirmed. We went back and we started again. And this time he dismissed on the ground that external restitution after the war, which ended in 1952, was the only federal policy. That went up to the Ninth Circuit for the second time. And a panel there made an historic decision where they, for the first time, said that even though they weren't treaties, the Washington Declaration and the Terrorism Declaration were the policy of the United States. And that policy was intended to get these pictures, this property, back to the victims of the Holocaust. That Marai von Sacher was the daughter-in-law of Jacques Houtstikker, and the plaintiff was the perfect plaintiff who was entitled to have her day in court to get these pictures back. And it was a major victory, applauded by people involved in Holocaust restitution all over the United States. They appealed but lost. They went to the Supreme Court and lost. It went back to the district court for a third time. And we said, oh, this is terrific. They're going to honor that historic decision of the Ninth Circuit. And instead, they ignored it. The judge ignored it. The same judge who dismissed the Cassera case, and said that, no, in the post-war restitution process and the Dutch Trading with the Enemy Act, it became the owner of whoever had it, who happened to be Herman Göring. So he basically said it was owned by Göring, and that's the Dutch government could take it as their property under the Trading with the Enemy Act.
Wow.
So we went up to the Ninth Circuit for a third time, and they basically ignored his decision, which was kind of odd, but then dismissed anyway on the active state doctrine. Another doctrine, which is a discretionary doctrine that the federal courts have, where they can, in their own discretion, decide by deciding this case rather than abstaining, they would interfere with the policies of a foreign government. Without going into detail, the events that they used to defer were very unlikely to have affected the Dutch government's policy. There were two decisions that were procedural, and it was the fact that they sold the picture, didn't restitute the picture, but sold the picture to the wrong people, the heirs of Stroganoff, who claimed it wrongfully in the 1960s. But the fact is that when the Dührers were taken by Göring, there were 200 pictures taken, 202 if you add them in. After the Washington Principles, the Dutch government revised its restitution process to make it much easier to get things back from the government. And those 200 pictures were, after a restitution process that we were involved in, returned all of those masterworks, among them, to Marai von Sacher. But these two pictures that were the same, in the same group of pictures, haven't been restituted, and the case is over. The Supreme Court, as MC said, like in most of these cases, didn't take the case. So, and there have been other cases, and they go on and on and on. There's the Scheppel case in Washington, D.C., which involves the heir of Baron Herzog. Many pictures were taken by the Hungarian government after the war. That case, I think, started in 2010, and it's still going on. It's been to the DC Circuit and the Supreme Court 3 or 4 times, and it's now going back to the Supreme Court again. The issues are too complex to discuss here, but they throw it again. Many impediments against these claims. They never get to the merits, which was the whole purpose of the Washington Principle and the Terrorism Declaration.
Well, let me turn to, I guess this is sort of a merits question, but we've actually got some audience questions that have to do with the role of art museums. So a couple of related questions. One is, are most disputed pieces in museums today, or are they located with private collectors or otherwise? And to what extent are these disputed pieces held by U.S. museums as opposed to foreign museums? Do we have any sense of the scope of that?
Again, we don't have a great sense of the scope of that. When they're discovered, the actions are brought. Many years ago, after the Washington Principles were adopted, a portal was set up where all American museums were supposed to take any picture, any piece of property that they had that was dated back to the period 1933 and 1940 to 1945, and where there was a gap in provenance and thus a possibility that it was looted art, put it on the portal so that people could see if they had claims or not. Of course, it was put on the portal with hardly any information, so it was hard to know. But as Stuart Eisenstadt, who was the person who created the Washington Conference, has been a leader in the field ever since, it's been very poorly used. There have been very few restitutions from American museums, very few objects identified. And we think that there are many, many, many more pictures and other objects of art in American museums that they're just not identifying and making known publicly. And one of the things we think should happen is that there should be transparency, either through federal legislation or otherwise, because self-regulation hasn't worked, in order to get museums to find out, it's their job to find out what is in their collection that has gaps in provenance between 1933 and 1945, and let the world know. European museums have been better equipped to restitute, mainly because they're mostly state museums. So the states, after the Washington Principles, adopted regimes, most of the countries that have the art, and have been returning it through proceedings. But the US, which is where they're mostly private museums, it's been hard to do that. The Department of State tried very hard to create some sort of national commission, but it just was not going to work because the museums weren't not going to give up the prerogative of them acting as judge and jury, so to speak.
And the statements, the statements of the museum organizations are very magnanimous sounding, in that their policy generally is that they would like to return these things, but it hasn't worked out in practice. And just for context in terms of how much might be in the United States, if you just think about it, there was a significant transfer of art throughout Europe during the war. Many of those countries enveloped in the war itself. The United States, while involved, was not a place where the war was happening, and we had money. So I would say a lot of it is here. Certainly it came to private collectors, and those private collectors, as happened in Zuckerman, donated it to a museum, and very often to a US museum. So I would think, just based on the flow of things, the flow of the pieces of art from Europe and where the market was, I would think there's a lot here still.
That makes sense. Well, I don't know if either of you would know this, but I mean, it would seem to me that, museums, even though they're typically not for-profit entities, I would think are responsive to reputational concerns. Are you aware, if you've been involved in efforts to create public pressure campaigns against museums to sort of shame them, for lack of a better word, for holding on to art that either clearly did belong to Holocaust victims, or where they have no good faith basis to think otherwise based on the lack of clear provenance during the wartime years? Is there sort of a non-legal solution that could be pursued to try and get some of these museums to do the right thing?
Can I say, and this may sound cynical, and there's exceptions. We've recovered property on behalf of plaintiffs from different American museums, but not the big ticket items, so to speak. And the fact of the matter is, I think the museums have no shame. And in just taking an example, in the Von Sacher case, the World Jewish Congress published an entire page ad, a full page ad in the LA Times during the course of the proceedings. And the intent was to do that. I mean, people talked about having a hunger strike on the steps of the Norton Simon Museum, but they didn't. But you'd figure there would be some reception to that. On top of that, one of the heirs of Norton Simon, who was involved with the boards, made some statements to the LA Times, but nothing came of it. We talked to the Metropolitan for years before bringing the suit, and the only invocation of the Washington principles was, well, they'll continue to talk to us. But that didn't accomplish anything except take time. So though, yes, there are exceptions, I think overall the American museum community has said we're going to rely on technical defenses, and they have done that.
Well, let's turn back then to the legal issues. So the HERE Act was passed by the US Congress in 2016, right? One of its primary purposes was to establish a uniform national statute of limitations. A purpose, of course, was to sort of prevent some of these procedural barriers to recovery that we've talked about, so we could actually get to recovery on the merits. Obviously, it didn't do the trick, at least the way the Second Circuit has interpreted it, and the Second Circuit covering within it New York, obviously, is very important for the art world. What can we do? Is the next step to try and lobby Congress to amend or add to the HERE Act, or what are the next steps to try and actually overcome some of these barriers?
Well, I think definitely the Congress should be lobbied to clarify the HERE Act, because I think the Second Circuit decision is totally off base. They relied on legislative history, which really shouldn't be invoked if you have a clear and unambiguous statute, and the preamble to the statute makes it crystal clear that it was to avoid this impediments and make these cases timely and get to the merits. And hopefully, after the COVID-19 situation ends, or at least we get back to near normal, that we can proceed with that in Congress. I think we can consider other legislation imposing some external obligations on institutions, at least, if not private collectors, to disclose the provenance of these and their research regarding this, and have an obligation to research it. is another, way that hopefully we can address these issues.
Do either of you know, I mean, I'm thinking, let's say that either the court got the HERE Act right in terms of the laches issue, or the HERE Act was clarified. It takes care, ostensibly, of that procedural bar, but there is still the issue of duress, because in the Zuckerman case itself, right, it was not the counterparty to the transaction that was actually exerting the pressure or threat. And that, at least according to the lower court, was dispositive. I mean, even if you could have gotten over that procedural barrier, wouldn't the fact that many people took advantage of Holocaust-era Jews' distress but didn't necessarily directly cause it, would that itself continue to be a barrier to recovery? Is there something that would need to be done to address that?
It shouldn't be. I mean, I think it was a big accomplishment in the Terrorism Declaration that it specifically and expressly stated that the wrongs would include sales under duress. The HERE Act specifically refers to the Terrorism Declaration and says that that's the policy we're going to effectuate here. It's interesting that just about the same time as the Lefman case, which was in federal court, there was a New York State case, Reif v. Nagy, that involved—
Sorry, what was the name again?
Reif, R-E-I-F v. Nagy, N-A-G-Y. I may be pronouncing that wrong. Involving a Sheila case, and a federal court in a case called Bakalar, B-A-K-A-L-A-R, had looked at the art from the same collectors, Jews who had been persecuted and died in the Holocaust, and didn't give it back. And then in the state court involving the same family, a different Sheila gave it back. And it was affirmed by the appellate division. They made reference to the HERE Act, and the lower court judge actually said that it's our job, this is a state court judge, under the HERE Act, it's our job to make sure that these cases promote the policies of the Terrorism Declaration and the Washington Principles. So I think there is hope. And duress, in my view, neither laches, which is MC described as a fact-specific defense. Did you delay unreasonably? What was the other side prejudiced? And duress, which is a fact-based action. Was there duress? How can you decide on the pleadings when duress was covered in 5 pages of horrific allegations? How can you decide on the pleading stage? So I do think there is hope for duress. There was a federal case called Shopes in which a district court judge in New York, prior to Lefman, specifically ruled that duress is an appropriate basis on which to bring these restitution cases, and also importantly said that unclean hands should be asserted against museums who didn't properly look at the provenance and who should have known that these had been misappropriated during the war.
That was the other thing.
That's a very important case. So I do see hope in the future, and I have this other cynical feeling that it's hard to win against major American museums. I think it's an subconscious feeling on courts in the United States that these are the cultural institutions that are very important to our country. And I think there's a subconscious feeling that, we don't want to have to rip out all of the important works from these museums and give it back to people 70 years after the fact. I may be wrong on that. I'm not sure, but I hope that it changes in the future.
That makes sense. MC, I don't know if you wanted to comment on that.
Yeah, I mean, I think from the museum's perspective, to be fair, that what they usually say is we have a fiduciary duty to our institution, and we have to do everything we can to maintain its treasures. And, we can't just sort of willingly give up these things. We need to be ordered by a court, basically, and to be very clear that we're not entitled to this. The challenge with that is that, you may have had it for that many years, but did you rightfully have it? and basically you sort of a windfall that you had it for that long. And in the greater good of things, maybe having a discussion with people and finding some potential middle ground will be possible. And some of the cases that were able to be resolved were resolved out of court with smaller institutions, not the larger ones, as Larry mentioned, agreeing to, well, we can keep the painting in our collection, or we can keep the piece of art in our collection, but we are going to pay you a portion of its value, and we're going to clearly note that it's from your family and it didn't come, we're going to clear up the provenance. So there are ways to resolve things, but it seems that the museums are getting more entrenched in not even seriously having those discussions anymore. And I do think it's what Larry mentioned, which is, they feel like this is part of our cultural value. I mean, you can think of the high value things. I mean, if the Picasso at the Met, which is one of the most famous Picassos, and the actor in the Zuckerman case, if they just gave that up, I mean, that would be a big problem. It was the same thing with Altman. The Klimt paintings were, especially one of them was one of the most famous and beloved by the Austrian people. So it's just, there's a lot of emotions there too, I think, understandably. But also, I think I would go a bit further in terms of my sense that I think that at this point, they're a little concerned that it's the tip of the iceberg. If we do one thing with one piece of art, it may turn out that we have a lot more. And then our whole collection would be thoroughly decimated. So we can't do the right thing in one particular case because there's going to be a domino effect. And so it isn't just this major piece in our collection. It could be a lot of our collection that could be subject to this. So they have more trepidation about that now. I have some thoughts about this, about, as Larry mentioned, there are some things that we could clarify. I think transparency is a good thing, but and the museum community had said for a while that they were going to do that voluntarily, but as you can see, even in the Zuckerman case, it wasn't really done. Yeah. And on the other hand, they had, some of the monuments men, like very famous people who helped recover all of these paintings from Germany on behalf of the Allies on the Metropolitan Museum of Art staff at the time. So you think, well, they had the best in the world to be able to find this out and to do the right thing, and they didn't. So I think that there's the museum issues, and then there's also the states. A lot of states and countries have things. Some of them, as Larry mentioned, have been better about returning things. But if it could be clarified about that the state basically is not holding these things sort of in fee simple with 100% right to these pieces of art during this time frame, but rather they're sort of, on loan or in perpetual trust or something like that, then it would be clear what role they were having at that time. And I think that the transfer back to a family would be more encouraged. And then also just, it's especially if you don't go through a major auction house and you do a private sale. If you're a private collector, it's very easy to transfer these pieces of art and to transfer ownership without sort of fear of somebody coming back for them. So if there could be some clarity around that question of ability to transfer. Now, we say many times in many of these cases that you can't get good title from a thief, and that is right. Generally the law in a lot of jurisdictions. But somehow there's a lot of different wiggle rooms around that and different arguments that people make. So if there were a more clear-cut view that would discourage people from transferring things, because you can't, it's very difficult on the front end to discourage large events like genocides and the Holocaust in particular from happening at all. But the aftermath, the people who traffic in it and transfer it and profit from somebody else's very ill fortune, maybe you can do something there to disincentivize the trafficking in it. If it's not as valuable and you can't transfer it back and forth, then maybe you're not going to buy it.
Let's hope. Yeah.
Yeah.
Well, these have been fantastic insights, and we are just about out of time. There were some fantastic audience questions we weren't able to get to as well. I apologize, but there was a lot to talk about here. We can only hope that there is more clarity in the law. We hope that people act in good faith going forward, or at a minimum, like you said, if we can't get people full restorative justice, at a minimum, if people can at least acknowledge the provenance and the history and at least give that symbolic reparation, that would be a step in the right direction. I want to thank you both for your time and sharing your expertise with us. I wish you both the best of luck in your future cases. I want to thank everyone who joined us today, and please keep an eye out. We'll be advertising our next Distinguished Speaker webinar in the coming months, and it's going to be in the lead up to the presidential election, and it's going to be about that topic. So stay tuned, everybody. Thank you and take care.
Thank you.
Thank you so much.